Good morning and welcome to our first Gough Square Live of 2023. It's on an important topic, the power of local authorities to prosecute outside their own area. You'll shortly be hearing from Kingham, Sabrina Goodchild and Cameron Crowe on that issue and the recent Court of Appeal case of the Crown and AUH. They'll consider the practical implications for trading standards going forward. And as usual, there'll be a Q&A following the talk, and you can ask questions using the Teams chat function or simply by emailing at the same email address on which your invitation came. Before I hand over, let me tell you about the next Gough Square Live. That will be Tuesday the 7th of March at 11 a.m. and the topic will be time limits and the developments following the cases of the Bakers of Nailsea and the recent case of the London Borough of Barking and Dagenham and Argos. I shall now hand you over to our team.
Hello and good morning. My name is Kingham and this is Sabrina Goodchild and we're both barristers at Gough Square Chambers specialising in consumer and trading standards work. As Jonathan mentioned, today we're talking about a recent Court of Appeal case called AUH. I say a case, it was actually such a big case that the Court of Appeal split it into two and gave two separate judgments in order to deal with all of the issues. The first judgment was handed down in August last year, and the second came out 2 weeks ago. And without over-egging it at all, I think it's fair to say that these are two of the biggest decisions for the trading standards community in a very long time, because they go to the heart of local authority powers and jurisdiction. Both judgments were given by the Lord Chief Justice, who heard arguments from our very own Jonathan Casey, who you just heard from Cameron Crowe, and from Sabrina Goodchild, who all represented the lead appellant, the NTS Crime team based at York, against 14 defence counsel, including 5 defence silks. And if that wasn't enough, the appeal was also conjoined with another case brought by Birmingham City Council. Both cases involved national trading standards teams. The City of York hosts the NTS Crime Unit, and Birmingham hosts the NTS Illegal Money Lending team. The York case was a prosecution for conspiracy to defraud, as well as resulting money laundering offences, whilst the Birmingham case was for illegal money lending. And in both cases, the offending had been committed all round the country throughout England and Wales. And with that in mind, the prosecution in both cases had principally relied on the relatively new powers of prosecution set out in the Consumer Rights Act 2015, specifically paragraph 46(1) of Schedule 5. That paragraph allows a local authority to bring proceedings for a consumer offence that is committed in a part of England or Wales which is outside that authority's area. The issue, of course, with that is that there's also the well-known provision in Section 222 of the Local Government Act 1972, which says that local authorities can bring proceedings where it's expedient for the promotion or protection of the inhabitants of their area. And that's often called the local expediency test. In other words, the test is whether a prosecution is in the interests of the people in your local area. And what the defence were arguing in both cases was that these prosecutions didn't meet that local expediency test because most of the offending took place all over the country rather than in York or in Birmingham. And even if you were using the power in paragraph 46 of the Consumer Rights Act to bring your case, you still needed to satisfy that local expediency test.
So why were these seemingly routine prosecutions so special? Well, the trial judges in both cases made contradictory decisions on the ability of local authorities to prosecute out of area when the local expediency test wasn't met. In Birmingham, the court held that the prosecution was still permitted, but in York, the court stayed the prosecution as an abuse of process. And this caused the resulting appeals to be joined together and for the Court of Appeal to decide the scope of local authority powers of prosecution for consumer offences. This morning we're going to run through the Lord Chief Justice's decision on first, the geographical constraints of paragraph 46, second, the meaning of consumer offences, how to prosecute where an offence is not a consumer offence, the circumstances in which the involvement of lawyers is required to prosecute regulatory offences, and then finally, the practical steps to consider before commencing a prosecution. We'll then, as is always usual, open up the floor for the Q&A session, which will be led by Cameron.
So, let's kick off with identifying the geographical boundaries to prosecutions under paragraph 46 of the Consumer Rights Act. This topic was considered in the first judgment of the Court of Appeal, which very clearly and concisely held that there are no geographical boundaries. Instead, paragraph 46 creates a freestanding power to prosecute entirely unconstrained by section 222. And what that means is that when you're prosecuting consumer offences, local authorities aren't restricted by the local expediency test in section 222, so you can prosecute offending wherever it takes place in England and Wales. So, of course, the question then is, well, what is a consumer offence? And it's quite really an important question, because if you're prosecuting a consumer offence, then you no longer need to worry about meeting the local expediency test. And this is one of the questions which the Court of Appeal considered in its second judgment.
So put simply, consumer offences fall into one of two categories, which I'm going to call Category 1 and then Category 2. And it's important to know which category your offence falls into. Now, Category 1 offences are very easy to identify because they're all created by legislation that's listed in Schedule 5 of the Consumer Rights Act. That list includes lots of the offences that we know and love, including, for example, offences under the Consumer Protection from Unfair Trading Regulations 2008. So, where an offence is created by the listed legislation, so for example, contravening professional diligence, you can prosecute it anywhere in the country. The second category of consumer offences is slightly more complicated, unfortunately. That second category is not created by legislation specifically listed in the Consumer Rights Act. Rather, they originate from an investigation into a breach of a Category 1 offence. And it was this category that the court were considering in the second appeal. The key question was, well, what is meant by originating from an investigation? Because unless you can prove that your Category 2 offence originates from an investigation into a Category 1 offence, then you can't rely upon paragraph 46, which means you're back to having to try and prove the connection with your local area under section 222.
In a significant win for local authorities, the Court of Appeal held that the offences prosecuted were, in fact, consumer offences. The Lord Chief Justice considered the meaning of the phrase originating from an investigation, and he said, and I quote, "In our view, Mr. Kirk was correct to submit that the phrase an investigation into a breach of legislation, etc., is apt to accommodate the subject matter of that investigation, that is to say, what is being investigated. The adjectival phrase originating from requires there to be some sort of connection between the particular consumer offence or offences being investigated and the further offence or offences which are revealed by the facts and matters being investigated." So the key question when you're deciding whether an offence originates from an investigation into a breach of one of the offences that is created by the legislation specifically listed in the Consumer Rights Act is whether the offending discovered is connected to the original offence that was being investigated.
Now, helpfully, the court gave two examples of connected offending. The first of which is the classic case, as applied in the York prosecution, of an investigation being undertaken into alleged breaches of this Consumer Protection from Unfair Trading Regs, which leads then to the discovery of the typical consequential offences, such as money laundering. Let's take, for example, the situation in which an authority receives a number of complaints from relatives of elderly people who have been cold called in their homes and subjected to high-pressure sales techniques to purchase drive retarmacking. Your investigation may initially be into offences under the Consumer Protection from Unfair Trading Regulations, so misleading actions and the like. But what if your investigation reveals that the tarmacking business is in fact far bigger than you initially thought? The sellers are running a nationwide ring with individuals, numerous individuals, involved in various different aspects of the criminality, along with hundreds of bank accounts all being used to move the proceeds of the crime around. You can see in that scenario that offences of money laundering and conspiracy to defraud clearly arise from the same underlying consumer detriment or complaint. They are connected to the original CPUT offending. Now, on the other hand, what if you then discover indecent images of a child on a computer that you've seized as part of your investigation into the tarmacking business? Well, quite clearly, this offending doesn't arise from the consumer detriment or complaint of missold tarmac. As a result, the local authority couldn't properly prosecute for the indecent images. Now, the second example that was given by the court is of an investigation into illegal money lending, which then reveals that violence or intimidation has been used or threatened to collect the money that was illegally lent to consumers. Again, that would originate from the underlying illegal money lending, because the discovered offending is connected to the original offending. It's offending to enforce loan repayment.
Those were the two examples that were given in the Court of Appeal's judgment. Let's consider two more of our own. One example where paragraph 46 could be used, and one where it couldn't. Taking the first example, say you have a number of consumer complaints made about an electronics store which is out of your area. People are saying that televisions and computers are being offered for sale as new, but very often, in fact, there are parts missing or the goods don't correspond to their description. An investigation starts on suspicion of misleading commercial practices under the Consumer Protection from Unfair Trading Regulations, but you later discover that actually the reason the goods don't often correspond to description is because they're all stolen and the shop is a fence for burglars. Using paragraph 46, you could prosecute for handling stolen goods under section 22 of the Theft Act, even though it's not listed as a consumer offence in the CRA, and even though your offending was taking place out of your local area. On the other hand, and for our last example, let's use a pub which is under investigation for short selling, or selling short measures. While you're at the pub investigating this, a fight breaks out and the offence of affray is committed. Whilst it's true that the offence took place during the investigation, ultimately the affray isn't actually connected with the original consumer offence under investigation, and so paragraph 46 doesn't apply. I think the main takeaway points from these examples is that you're going to have to look at the facts of each case closely before you can know whether or not you can prosecute out of area for an offence that isn't created by legislation listed in the Consumer Rights Act. And that should be relatively clear-cut in the majority of cases you come across, as we've hopefully demonstrated with our examples. So, let's stand back for a moment and return to the question of why these appeals are so important. In a nutshell, they're important because they provide a complete answer to jurisdictional challenges where consumer offences are being prosecuted. And that should put a stop to one of the most common avenues of attack by defendants in these cases.
Now, the focus of our talk has been on paragraph 46 and prosecuting out of area. But what do you do when the Consumer Rights Act simply doesn't apply because the offending you've discovered isn't a consumer offence? Well, it's at this point that it's very, very important not to forget about section 222, which permits prosecutions, as we've already said, where it's expedient for the promotion or protection of the inhabitants, of the interests of the inhabitants of their area. Let's go back to the pub example in which you're investigating the short measures. Let's say that when you use the bathroom, you discover it's dangerous. The handles to the bathroom taps have been snapped off, creating sharp metal edges that must be held in order to operate the tap. Health and safety offences aren't created by legislation listed in the Consumer Rights Act, and the unsafe tap isn't connected with the original offence of selling short measures. However, in this example, let's say the pub is actually within your local area, which means you may be able to rely upon Section 222, even though the health and safety offences aren't consumer offences. And of course, that's where all of the usual Section 222 case law comes into play on what is meant by the local expediency test. And I think that's fair to say that is a discussion very much for another day, perhaps.
Moving on, another topic which was considered in the judgment is the extent to which lawyers have to be involved in prosecuting these offences. And helpfully, the Court of Appeal have confirmed our understanding, which has been widely held across local authorities for a long time, that Section 223, not 222, but Section 223 of the Local Government Act permits local authorities to act without solicitors when they're in the magistrates' court. And that means that officers can investigate the offending, lay informations, serve evidence, appear at the first appearance, and so on, all without the involvement of solicitors. And where the case is then set down for trial in the magistrates' court, the whole proceedings, in fact, can be conducted without the input of any solicitor. So officers can undertake disclosure, serve evidence, deal with queries from the defence, and instruct experts. In effect, they can deal with everything from start to finish in proceedings in the magistrates' court.
Now, the second useful part of the judgment is that even if a local authority has acted without lawyers in the Crown Court, the proceedings will still usually be lawful because they were commenced lawfully by the officers in the magistrates' court, where, of course, as Robin said, no solicitor is needed. Indeed, in the York case, the Court of Appeal approved the trial judge's conclusions that the officer involved had acted, and I quote here, apologies, I'm just going to take a sip of water, as scrupulously as possible throughout, leaned heavily upon instructed counsel, and made every attempt to conduct litigation fairly. In reality, acting in the Crown Court without a lawyer is only going to be abusive where it happens in bad faith, where proceedings weren't conducted properly, or where there's been some other prejudice to the defendant as a result. However, that's not the end of it. The Court of Appeal did sound a note of caution when cases leave the magistrates' court and are sent to the Crown Court. The court found that even simple steps, such as emailing the indictment to the court and the defence, may in fact amount to the conduct of proceedings and consequently breach the Legal Services Act. What this means is that as soon as a case is sent from the magistrates' court to the Crown Court, a solicitor should be instructed and the litigation conducted by them. And the same goes for an appeal of a claim that was dealt with at first instance in the magistrates' court.
So, what are the practical points to take away from today? Well, the single most important point is to make sure that you as an authority are clear about which powers you're using to prosecute. Is this a Section 222 case, or is it a Consumer Rights Act case, or is it both? And it's going to be important to have a written record of the jurisdictional basis for the commencement of proceedings. And that written record is going to need to be in a form which can be disclosed to the defence. So not just in counsel's advice on charge or in a sensitive investigation report or something similar, because you can expect defence teams now to be looking very closely at the jurisdiction that you've exercised, and you're going to want to be able to serve some evidence of how the investigation started and which powers you're using. We here at Gough Square would suggest that every local authority actually has a template form. It doesn't need to be more than a page, but it should set out what the initial offences were at the start of the investigation, which jurisdictional powers are being used to prosecute and why. And if the investigation changes nature so that you're looking at prosecuting potentially different offences, from those that you had originally anticipated, then that should be recorded on the form. And hopefully that should also then prompt you to have a think about which jurisdictional powers you're going to use to prosecute and whether they're still appropriate as the investigation goes on.
So, to take our earlier example of the retarmacking business, you might start off recording on the form that you're investigating breaches of the consumer protection from unfair trading regulations within your local area, and that you intend to prosecute using your powers under section 222 as everything is within area. Later, your investigation takes you out of area to discover evidence of the countrywide conspiracy to defraud that we've already discussed. The business is far bigger and more complicated than you first imagine. You can return then to the form and indicate that the investigation has been broadened to include conspiracy to defraud. You can also record on the form that you intend to prosecute these offences using the Consumer Rights Act, because the conspiracy offence is clearly connected to the original consumer offence under investigation. And of course, it'll be important to have that simple record setting this out in a form that you can disclose to the defence, just in case they start asking questions about why your team is prosecuting conspiracy to defraud. Now, if there's enough interest, we here at Gough Square are more than happy to put together a template form like the one that we both outlined and share it with all of you on the call. So do let us know through email whether that would be helpful, and we can of course have a go at drafting it. So that then concludes the main body of our talk. And we are now going to hand over to Cameron, who is going to miraculously appear on your screen in a moment of seconds, who I understand has been shifting through the questions that have been received in order to deal with them. So I'll let Cameron now join us.
Hello everyone. When Sabrina described my appearance as miraculous, it was literally walking from there to here, which, well, I'll take the miraculous in that circumstance. So today hasn't exactly been the 9 o'clock news. It wasn't even the 11 o'clock news. I think it was more the 7 minutes past 11 o'clock news. So we're sorry about the technical difficulties at the beginning. The majority of the Q&A was taken up with the fact that the sound was turned off at the beginning, or they appeared to think that it was turned off. Hopefully that was resolved and everyone's been able to hear. We didn't get bombarded with questions, which is probably a reflection on the clarity with which these two have delivered the summary of what was decided in the Court of Appeal. But we did have 3 in advance. The first is, does the judgment on the Legal Services Act point mean that applications for orders under the Proceeds of Crime Act as part of the investigation must be undertaken by solicitors? Well, the answer to that is no, for 2 reasons. The first reason is that it is clear, following the case of Qualter and Preston Crown Court, which I'm sure you're all familiar with, that a local authority is entitled to investigate given its general power of competence under Section 1 of the Localism Act 2011. The second reason is that the Proceeds of Crime Act provides specifically for non-lawyers to make applications in relation to production orders, which I imagine will fall the lion's share of investigative applications. It's section 345, which says appropriate officers can make the applications, and section 378, which defines appropriate officers as including accredited financial investigators, and it is they who undertake the majority of these applications in our experience. And with regards to restraint orders, which may be the other application commonly dealt with by you, they can be made by a prosecutor or accredited financial investigator, and that you find in section 42, subsection 2 of the Act. So hopefully that answers that question. Secondly, can you still prosecute using paragraph 46 if the consumer complaint from which the investigation originated is out of time? It's a very good question. Again, the answer is yes. you are still entitled to investigate in accordance with, again, the decision in Qualter and the Localism Act, of course, but there will, of course, need to be the necessary connection between the consumer complaint and the facts and detriment surrounding it under investigation and the offence that you ultimately prosecute. Does it arise from the consumer detriment you are investigating will be the key question to ask yourselves. Thirdly, the final question we have is, if offenders are operating abroad rather than in England and Wales, can they still be prosecuted using paragraph 46? And again, the answer is yes, in our view. The general rule is that an offence, and I emphasise offence, may be committed in England and Wales, even where some elements or consequences occur abroad. So if this is being aimed at consumers based in England and Wales, then the offence is being committed at least in part here. Even a secondary offender, so someone who aids or abets the principal, may be criminally liable, even if they have personally done nothing within the jurisdiction whatsoever. And there's a particular case on this called Robert Miller Contractors Limited. It's a 1970s case, so this is well-established principle, in which a Scottish haulage company and its managing director were convicted as secondary offenders of death by dangerous driving. The driver had pleaded guilty to the offence, but the managing director knew, having never come to England, that the lorry in question had a defect which resulted in a tyre blowing out and killing someone when travelling at speed. The managing director argued that he'd never been to England, he was never within its jurisdiction, but the Court of Appeal found that he had participated in the crime which occurred in England and was therefore criminally liable. The point to take in relation to question 3 ultimately is that it's likely fact-specific and requiring of analysis, and so you might want to get some advice in the circumstances. They're the 3 questions we had. I hope you've found the talk useful. I certainly did, and I was in the Court of Appeal, so having it summarised to me was extremely beneficial. You've been told that the next Gough Square Live, I believe, is on the 7th of March, and it's going to relate to developments on time limits, including the time limits for us to actually start on time. 11 o'clock, we say. Hopefully it won't be 7 past on this occasion. If it is, we're out of time. Anyway, that concludes things for today. We hope you enjoyed it. It's goodbye from me, Robin, and Sabrina.
Goodbye. Thank you.